I was somewhat anxious. I was interested in going. I had never been been on a jury before, but I had two small children at the time, and I was concerned about the amount of time it might take.
I think everybody has that moment of a little bit of internal eye roll when you get the juror summons in the mail.
When I got the notice that I was going to serve, my first thought, of course, was, gee, am I going to be able to fit this in? How's this going to affect my work? How long is the trial going to be?
Everyone is treated exactly the same, no matter what his or her station in life is. And in this situation, I received a summons, and I did exactly the same things as each and every other juror who receives a summons does.
Welcome, and thank you for your time with this important responsibility of serving as a juror. I'm Ed Sardella. We know this may not be where you'd like to be right now. You may view jury duty as an inconvenience and a disruption in your daily routine. It also may be somewhat overwhelming, not knowing exactly where you're supposed to be, what you're expected to do, and how the process works. This program will answer many of your questions and help you feel more comfortable as a juror. The truth is, by the end of this process, you may gain a greater understanding and appreciation of justice in America. Without you, this system won't work. Jury duty is a responsibility that we all share. It's a foundation of American freedom. The framers of our Constitution established trial by jury, and it's a vital part of our heritage. More than 200 years ago, American colonists so cherished these rights, they fought to preserve them. Today, you're helping to preserve these same fundamental rights. You might be asking yourself, why me? Do I have to be here? Why can't it be someone else who doesn't have as many important things to do? How long will this take? The selection process is completely random. Your name was drawn from a pool that includes voter records, driver's licenses, non-driver IDs, and state income tax returns. Colorado courts use a jury system called one day, one trial. This system assures there will be enough jurors, and it helps make the process easier for you, and also helps make the best use of your time. One day, one trial means you participate in the selection process for one day, or you may be assigned to one trial. The average trial in Colorado lasts 1 to 3 days. If you are selected to serve as a juror, you will serve until the trial is complete. In most counties, you can be called for jury service by the state courts only once in a calendar year. Some people have been excused from jury duty, or they've had their service postponed due to their personal situations. This is based on the criteria on the back of the jury summons. If you're looking to be disqualified or have your service postponed today by the jury commissioner, it's too late. However, if you still believe you have a valid reason to be excused, you'll have the opportunity to speak to the judge. Jury service is your responsibility. But for those of you who are chosen to serve on a jury, think of it more as a privilege of living in a free society. After all, you never know if one day you might want a jury for your case. Remember, today is a very important day for the parties in the case you will hear. You owe it to them to take your role as a juror very seriously. In Colorado, you may be part of a 3, 6, or 12-person jury, depending on the type of case to which you're assigned. 3-person juries hear civil cases. 6-person juries hear misdemeanor cases involving more serious criminal charges. 6-person juries also hear more complex civil cases. And 12-person juries hear felony cases involving the most serious crimes. For many trials, one or more alternate jurors will also hear the case. Alternates are additional people who are chosen at random in the event another juror cannot serve. An alternate juror participates in the trial just like all other jurors until excused by the court. You won't know if you are the alternate until just before deliberations begin. Who else will be in the courtroom? Let's start with the court staff. The judge, who sits behind a desk called the bench, presides over the trial, making rulings on the law and setting the tone of the proceedings. The judge is responsible for protecting the rights of all concerned and ensuring that the trial is orderly and fair. The courtroom clerk sits near the judge. The clerk is responsible for assisting the judge in creating a summary of the proceedings for the official court file. The judge or the clerk may administer the oath to jurors and witnesses. A court reporter may sit near the witness stand with a small typewriter-like machine, making a written record of everything that is spoken in court. In many courtrooms, however, a court reporter is not present. Instead, the proceedings are recorded electronically. The clerk or court reporter is responsible for keeping track of evidence and exhibits. In some courtrooms, the jury commissioner will remain with jurors throughout the trial. The jury commissioner may also serve as the clerk and bailiff. A court interpreter may assist when one of the participants does not understand English or is hearing impaired. The interpreter will translate exactly what is being said. In some courtrooms, a bailiff maintains order and security and will serve as your liaison with the judge. A law enforcement officer may also provide courtroom security. These individuals comprise the courtroom staff. Now for the parties in the trial. In a criminal case, the prosecutor, typically from the district attorney's office, files the charges and represents the people of the state of Colorado. The defendant in a criminal case is the person who's been charged with a crime. A lawyer may represent him or her, or they may choose to represent themselves. In a civil case, the plaintiff is the individual who has filed the lawsuit. The plaintiff or the plaintiff's attorney argues their side of the case. In a civil case, the defendant is the party who is being sued. The defendant may or may not be represented by an attorney. Generally, courtrooms are open to the public. Anyone who is interested may observe the proceedings.
Everyone had such a feeling of responsibility, a feeling that they wanted the right result to happen, that I think any typical personality problems that might arise didn't. People felt a responsibility toward the court and the defendant.
And there's always a little trepidation about you're going to be up there and interviewed by lawyers and all this kind of stuff. But it worked more or less as I had hoped.
Now for the selection process. As prospective jurors, you'll be chosen at random to sit either in the jury box, at the front of the courtroom, or in the public seating area. If you are seated in the jury box or at the front of the courtroom, you may be asked questions by the judge and the parties. Everyone must listen carefully to all of the questioning. Your turn may be next. This questioning is called voir dire, which means to speak the truth. Its purpose is to help the judge and parties learn more about you, so they can decide if you will be an impartial juror in the case at hand. You may be asked many questions about your personal experiences and opinions. If you feel especially uncomfortable answering a specific question in front of other jurors, you may ask the judge to let you answer it in private. However, you must remember you'll be under oath to answer all questions honestly, and your response becomes a part of the court record. In some cases, you may be given a written questionnaire prior to voir dire. There are two ways you may be excused: challenges for cause and peremptory challenges. Challenges for cause allow the judge to excuse any number of prospective jurors for reasons specified by law. A peremptory challenge is when a party can excuse you without stating a reason. The number of peremptory challenges allowed can vary from case to case. Don't be concerned or embarrassed if you're excused from this jury. You may be assigned to another trial where you may be a perfect fit. Once all challenges are complete, the jury is seated. The next phase of the trial is ready to begin. The jurors will now take an oath, promising to fairly decide the case. The judge will instruct the jurors on how to conduct themselves during the trial. This applies both inside and out of the courtroom. It's not unusual for the judge to place restrictions on you while you are a potential juror or while serving on a jury. For example, you may not be allowed to communicate by any means what is happening in the trial until a verdict is announced in court. This includes all forms of electronic communication, such as cell phones, email, text messaging, tweeting, blogging, internet chat rooms, or by way of any other social networking website, including Facebook, MySpace, LinkedIn, and YouTube. You may not conduct any independent research, view or listen to media reports, or access any information via the internet or by any other means of research. You may not Google or conduct any internet search regarding this case, its participants, the type of case, definition of words used in the courtroom, or any related subject matter. If you have any type of electronic device with you, it must be turned off at all times while in the courtroom and during jury deliberations. The judge will let you know that although you may notify your family and your employer that you have been selected to be a juror and how long the trial may last, you may not say anything else to them about the case until it's over and your service as a juror has ended. There are many types of trials in which jurors serve. A criminal case is brought to trial by the government. It charges an individual accused of committing a crime. A civil case is a dispute between one or more individuals, groups, and businesses or government agencies. What can you expect when a trial begins? We'll use a criminal trial as an example, but keep in mind, there are many parallels between criminal and civil trials. Each side may begin with an opening statement. An opening statement is to help you understand the evidence that a party anticipates may be presented during the trial. The opening statements are not considered evidence. Next comes the presentation of testimony and evidence. Many times, witnesses may include experts in specific subjects. A great deal of information will be presented, so you may want to take notes. Note paper is available, and you may be provided a notebook at the start of the trial. But don't get so involved in taking notes that you can't fully concentrate on the proceedings. Listen carefully to all testimony. Keep an open mind. The prosecution in a criminal case has the burden of proving the case beyond a reasonable doubt. In a criminal case, the defendant is presumed innocent. The prosecution will begin by calling its first witness to testify and may introduce physical evidence. The defense can then ask its questions. This is called cross-examination. The prosecution can come back again with additional questions for clarification. This is called redirect examination. This process is repeated with every witness. During the trial, you may be allowed to submit written questions for a witness at the conclusion of each witness's testimony. Court personnel will collect any written questions and deliver them to the judge. Your questions will be subject to objections by both sides of the case. The judge ultimately decides which questions, if any, are allowed. After the prosecution has introduced all of its testimony and evidence, it rests its case. The same procedure is used if the defense presents a case. However, the defendant does not have to prove his or her innocence, call any witnesses, or introduce any evidence.
Objection, Your Honor. Leading the witness.
During the course of the trial, either side may object to testimony or evidence. Most of the time, the judge will rule immediately. In some instances, the argument may require a private discussion outside hearing range of the jury. This discussion may take place at the bench, or you may be excused until the motion is heard. When both the prosecution and defense have rested their cases, the judge will instruct the jury on the law that must be applied to the case. Instructions can be both written and oral. They outline how the laws apply to the charges or claims. Then, each side may make a closing argument. Like opening statements, closing arguments are not evidence. Remember, closing arguments are addressed to you, the jurors. Again, you will need to listen carefully. The judge then identifies any remaining alternate jurors and dismisses them. The jury will then be escorted to the jury room to begin deliberations. As a jury, you must choose a jury foreperson. This is the person who will facilitate the process of discussing the case and reaching a verdict. The deliberation period is an opportunity for you, as one member of the jury, to state your thoughts and opinions about the testimony and the evidence introduced during the trial.
You know, I think it's going to be debatable.
Don't be shy. Remember, each juror is an equal participant, and it is your responsibility to speak up and provide your input. There is no time limit on deliberations. It is important not to feel improperly pressured by other jurors. Make sure you take the time to review all of the evidence in the case. At the end of deliberations, you will all vote on a verdict. When a verdict is reached, you'll return to the courtroom. The foreperson will deliver the written verdict to the judge. Once the trial is over, you may have the opportunity to speak to the parties in the case, but you're not obligated to do so.
Well, it was a terrific experience from my perspective because we immediately bonded from the time we got into the jury room. The rules were that everyone was on a first-name basis.
I was impressed with my fellow jurors and how they conducted themselves. Because, you know, you meet people and you tend to think, oh, this person does this kind of job, or he or she's retired, or geez, they were kind of rubbing me the wrong way in casual conversation and so forth. And yet when it came to actually doing the business of deciding the facts of the case, I think people were very serious about it. I think they were fair. And I think they took their responsibility seriously.
Everybody had to say. I mean, we basically, we would point at somebody. We had our juror numbers, and we would point, you got something? And everybody had to say something on every issue we brought up and talked about. There was no chance to remain silent.
We made a point of going around the room and making sure that everybody did say something, even if it was just a word of agreement or a word of disagreement, to make sure that everybody was heard. But I think it's important for even people who are introverts, and I tend to be one myself, to make a point to make your opinion heard when you're in that deliberation room, because everybody's opinion counts.
Welcome. I'm Chief Judge Michael Martinez. I've presided over many trials, and in every case, my goal was to ensure that justice was served. Our system of justice works well because of people like you, devoting your very important time and energy.
I'm Judge Karen Ashby. Serving as a juror is not only a great responsibility, but also a great opportunity. Today, you'll get an inside look into how your system of justice works and why it's such a treasured cornerstone of our country.
I'm Judge John Marcucci. Most people begin serving on a jury because they were selected and had no other choice. However, many complete their service with a sense of accomplishment and gratification.
I'm Chief Justice Nancy Rice. When this country was founded, one of the most important rights that was secured by the Constitution was the right to trial by jury. This right allows people to resolve their disputes without violence and without fear that the people making the decisions have a stake in the outcome. In other words, the right to a trial by jury guarantees that decisions are made by reasonable, impartial, and fair members of the community. The most important decisions made in a courtroom are made by you, the jury. Your role in the courtroom is more important than the roles of the lawyers and even the role of the judge. Because when members of the community come together as a jury and see the evidence in the same way, there's great confidence in their decision. Being on a jury is a major event. It's democracy in action. Thank you.
The judges and parties are now attending to last-minute details preparing for the trial. Your jury commissioner will tell you what happens next. Thank you for your attention and your service.